Good morning. The summary which I am about to give is a summary of the Supreme Court's decision in R on the application of TN Vietnam and the Home Secretary. Asylum claims are often factually complex, and this appeal is no exception. However, the principal point in the appeal to this court is a point of law, whether the order made following an appeal against rejection of her asylum claim, the refusal of the Secretary of State to grant the appellant asylum was unlawful and should automatically be set aside on the grounds that the determination had been unfair because it was under a structurally unfair system of rules. The appellant, whom I will call T, is an asylum seeker from Vietnam. T had arrived in the UK in 2004. She unsuccessfully claimed asylum based on religious persecution. She was removed by the Secretary of State to Vietnam in 2012, but she returned to the UK 2 years later. The appellant's second claim was made when the authorities discovered that she was again in the UK. The appellant made another asylum claim based on religious persecution occurring after she was removed from the UK. The Secretary of State rejected the appellant's claim, and she appealed to the first-tier tribunal. Her appeal was heard under the following set of rules: the Asylum and Immigration Tribunal Fast Track Procedure Rules 2005. I will call these rules the FTR 2005. In particular, these rules provided for an accelerated timetable for the parties to prepare an appeal to the first-tier tribunal and also for the hearing of the appeal. The appellant's case was that she had been detained and that while in detention, she had been tortured by the Vietnamese authorities in 2012, and also that she had been raped during her subsequent journey to the UK and in the UK. The first-tier tribunal rejected her appeal, and it found that her account was not credible. In 2014, after the appeal was dismissed, the FTR 2005 were replaced by another set of fast-track procedure rules. These are the FTR 2014. In a different set of proceedings, the Court of Appeal held that the FTR 2014 should be quashed because they were unstructurally unfair and there was a risk of unfairness to individual appellants. The Court of Appeal in that case did not deal with the question whether the individual determination of appeals should also be quashed. If that were to happen, of course, there would be many cases which the tribunals would have to rehear. T started judicial review proceedings. She alleged that the FTR 2005 ought to be quashed, and further that meant that the order rejecting her asylum appeal should also be quashed. T raised fresh submissions asserting in some respects a new case. She alleged she had been a victim of trafficking and sexual exploitation during her journey to the UK and while in the UK. However, the Secretary of State refused to accept that the submissions amounted to a fresh claim for asylum, which the Secretary of State would have to deal with. The High Court concluded that the FTR 2005 should also be quashed for similar reasons given to those given by the Court of Appeal in relation to the FTR 2014. However, the High Court held that the actual hearing by the first-tier tribunal had, in her case, in T's case, had been fair. But the Secretary of State should have found that the new submissions amounted to a fresh claim, a fresh asylum claim. That claim has not yet been determined. T next appealed to the Court of Appeal, which came to the same conclusion as the High Court. Lord Justice Singh gave the leading judgment. On the question of automatic nullity, He held that if the FTT were the first-tier tribunal, in determining an individual appeal, did so in a way that was procedurally unfair, it would not be acting without jurisdiction, and unfairness would have to be shown in the individual case. This was Lord Justice Singh's jurisdictional reason, so that it would have to be acting without jurisdiction. T finally appealed to this court. I gave the first judgment. I rejected T's principal submission that the FTT's determination was automatically a nullity and without effect. The fact that the system was structurally unfair did not mean that it operated unfairly in every case. Agreeing with Lord Sales, I also accepted Lord Justice Singh's jurisdictional reasoning. T had failed to show that the rules impacted adversely on her. I agreed with the conclusions reached below on the absence of unfairness in T's case, and I found no error of law. Lord Sales also agrees with Lord Justice Singh's jurisdictional reason and amplifies the conceptual distinction between ultra vires and procedural unfairness in an individual case. There were other points in the case, but it's not necessary for me to deal with those. They were all rejected, and accordingly the Supreme Court dismissed T's appeal. That is the end of the summary, and I thank you for your attention.